So, are you a bit confused about how all of your social media stuff, your online banking information, or cryptocurrency will be accessed if you no longer are able? If you're not confused or worried and have these things, perhaps you should be. Listen closely, and we're going to share why. I'm 𝗷𝗺𝗶𝗵𝗏 of 𝗬Metti Law, an estate planning attorney in New York and New Jersey, and we provide peace of mind to families through our very high client value estate planning and probate administration services. If you're seeking assistance for either of these in New York or New Jersey, you can reach out to us for a free consultation at yourplanningattorney.com. That's yourplanningattorney.com. And speaking of value, we are here to educate everyone for free. So ask us your questions and share so together we can help some folks along the way. Now, first, without a plan whatsoever, without any specific direction as to who can handle your digital assets and some other key information, much of what you have in your electronic world could be lost forever. So what does this mean? Many typical assets, right, like your financial accounts, a life insurance policy, maybe a tax refund, those types of things, the normal course of banking transactions, finances, those items will eventually end up in the hands of the state where the person was a resident at their death. But when an unknown account has remained untouched for a period of anywhere from 3 to 5 years, that's when it eventually will go to the state. However, this requires constantly checking to see if anything has showed up in the state, what they call unclaimed funds. And if you think about this, even if it does eventually go there, you've lost many, many years of potential growth, right? Interest, dividend, capital gain growth on those assets that could have been used in other ways. So sort of a waste in my eyes because your family didn't have the right information. Further, if you think about cryptocurrency, this is even riskier, right? So those held on an exchange of some kind will probably go through that same unclaimed funds process and end up in the hands of the state. But those held in a private wallet could be lost forever if you don't properly have a means of passing the relevant information along. And there are enough examples of individuals, younger and older, with sizable wealth in crypto that was lost forever because they died unexpectedly without having shared the information with their family. Just to give you one example, the American banking heir, Matthew Mellon, presumably has lost, or they've kind of affirmed, $500 million in crypto. That's bananas is my new word. That's crazy. Granted, maybe many of us, anybody who does have crypto as part of their investment portfolio, probably not $500 million. Maybe some people do. Many people do, I guess, but not everyone. Even still, whatever you do have could be lost forever if that information is not shared. So what's to be done, right? You have to take specific steps to insulate your information so it wasn't all for nothing. First, right, you want to name the trusted person to manage your digital assets under your estate plan. Now, often this is one of the powers, basically, that you would give to, say, the trustee under your trust agreement. Since that's also the individual who handles all of the other financial matters when you're unable at either incapacity or passing. So commonly, that's who you would designate. Then it's important to know that every state, I think all but one, have adopted the Uniform Fiduciary Access to Digital Assets Act. I had to read that one. And that kind of provides the guidelines for the custodian of the information, right? Think Instagram, whoever the crypto company is, and your email platform even. It gives them guidelines as to what they can release when, And really, quite frankly, there's two concerns. The first being it gives them, the custodian, a lot of discretion as to what it is that they are releasing to your family members. And secondarily, many of the platforms, think Apple, Google, Microsoft, they have their own restrictions that could be beyond that of, the guidelines set by the act. So, I guess my third point, first naming someone under your estate plan, knowing that these guidelines exist and that there could be specific ones for various platforms, is if the platforms that you use do have specific, designations for responsible parties in case of a drastic change in your health, do it. Right? You should do that. Make sure you designate the person who will have access to your material. It will make it much easier if it is the same person that you've designated throughout your estate plan, say the trustee, right, who's handling the financial matters, and also just make it a little smoother for those particular accounts. Now, lastly, it is imperative in all of these things and make it 10, 100 times smoother for your family should something happen to you. If you have a secured way to save, maintain, and share all of your digital asset information, doesn't mean that they have access to it now, right? It's just that it's there for that time. Now, this could be anything from, your Twitter account username and password, right? Access to your personal credit card account, or your $200,000 in Bitcoin, right? It all counts, and your family doesn't have a clue it even exists possibly, or how to gain access to it without the organized information from you, right? For when that time comes. So again, I'm Valerie 𝗵𝗵𝗶𝗵𝗶 of 𝗵𝗵𝗶 Law. We're an estate planning firm in New York and New Jersey, and we provide peace of mind to families through our high client value planning and administration services. You can reach us at yourplanningattorney.com should you be interested in a free consultation about these matters. We hope you've learned something new here today, and please don't forget to share and take care.